done, we will then take questions from the floor and also through WhatsApp from the colleagues who are joining us via that platform. Without further ado, let me hand over to the Public Protector to take us through the statement. Over to you, baby.
Good afternoon, Program Director. Thank you so much, Mr. Sekhalwe, Deputy Public Protector, CEO, Acting COO, Chief of Staff, the Executive Manager, staff of the Public Protector, the media, ladies and gentlemen. Thank you so much once more. I welcome you to all our monthly media briefing. As we've said over and over that now we will have monthly media briefings. A platform where we reveal to the public that which has been uncovered through our investigative work in compliance with Section 182, subsection 5 of the Constitution of the Republic, read with the Section 8 of the Public Protector Act. Today we have 5 reports. We have made adverse findings in 2 of these reports. The 2 others are advisory reports, while the last one is a report making the closure of an investigation. As you may be aware, we issue advisory reports in cases where there are no adverse findings, but observations that point to the need for the respondents to do things differently. Closing reports, on the other hand, are issued in cases where allegations that gave rise to the investigation are unsubstantiated, or where our preliminary investigation suggests that we do not enjoy jurisdiction to deal with the matter. All the 5 investigations we dealt with relates to legal aid at the expense of the state, pension in relation to the public sector, public education, accountability in respect of the use of funds flowing from public purse to political parties represented in Parliament for party political activities, and maladministration and or corruption involving certain persons within the Constitutional Court. The first report relates to NEDI versus Legal Aid South Africa. We investigated allegations of failure by the East London Justice Centre of Legal Aid South Africa to defend Mrs. Ndombe Kaya NEDI in divorce proceedings against her ex-husband, Mr. NEDI, in the East London Regional Court on November 7, 2012. The investigation followed a complaint that the Public Service Commission referred to the Public Protector on behalf of Mrs. NEDI in January 2019. On October 5, 2012, Mrs. NEDI was allegedly served with summons to defend divorce proceedings that Mr. NEDI, with whom she had entered into a civil marriage in October 2009, instituted against her. She allegedly visited the Justice Centre in East London to apply for legal assistance. She allegedly communicated with a certain Mr. Gutsia, who was a civil professional assistant at LASA, and advised him that she required a legal representative to assist her get a 50% portion of Mr. NEDI's pension benefits. She allegedly received no further communication thereafter from LASA until 2016, when she crossed paths with Mr. NEDI, who informed her that they were legally divorced on the 7th of November 2012. Mr. NEDI's claim was confirmed to Mrs. NEDI when she approached the East London Regional Court to verify the information. In essence, Mrs. NEDI alleged that LASA's failure to defend her in the divorce proceedings against her ex-husband was improper and prejudiced her. Having studied and analyzed the complaint, we decided to look into whether LASA failed to defend Mrs. NEDI in the divorce proceedings held on the 7th of November 2012 in the East London Regional Court, and if yes, whether the conduct of LASA was improper and constitutes maladministration. Our investigation established that indeed LASA failed to defend Mrs. NEDI in the divorce proceedings before the Regional Court in East London on November 7, 2012. Evidence in our possession revealed that Mrs. NEDI applied for legal assistance at LASA on the 10th of October 2012. An employee of LASA, a certain Mr. Liwani, who at the time was a paralegal, opened a file, and Mrs. Salman, another employee, who at the time was a legal practitioner, drafted the notice of intention to defend. So LASA's failure to file the notice of intention to defend within 10 days was at variance with Rule 13.1 of the Uniform Rules regulating the conduct of the proceedings of the Magistrates Court, which provides that the defendant in every civil action shall be allowed 10 days after service of summons on him or her within which to deliver a notice of intention to defend, either personally or through his or her attorney. That is provided that the period between November 16 and January 15, both inclusive, shall not be counted in the time within which to deliver a notice of intention to defend. Further evidence at our disposal revealed that LASA subsequently closed Mrs. Netty's file without providing her with any written reasons for the termination of her legal representation in the matter. She was also not provided with the outcome of her request for legal assistance. Again, this failure by LASA to notify Mrs. Netty in writing about the termination of legal representation is at odds with paragraph 11.1.2 D and F of the 12th edition of the Legal Aid Guide of 2012. That paragraph categorically states that on termination of a matter, should a Justice Center executive become aware after the instruction has been issued that the legal practitioner or the applicant is not proceeding with the matter, the JCE, which is this Justice Center executive, must terminate the instruction in writing and index the letter terminating the instruction to the matter's file and thereafter close the matter. The LASA's failure in this regard also offends Section 195(1) F and G of the Constitution, which states that the public administration must be accountable, transparent, must be fostered by providing the public with timely, accessible, and accurate information. Similarly, LASA's failure to defend Mrs. Netty in her divorce litigation cannot be reconciled with the dictates of Section 3 of the Legal Aid Act, which states that the objects of the LASA are to render or make available legal aid and legal advice, provide legal representation to persons at state expense, and provide education and information concerning legal rights and obligations as envisaged in the Constitution and in the Legal Aid Act. Further evidence placed before us indicated that LASA reactivated the file only on the 18th of February 2013 and requested Mrs. Netty to give further instructions. However, LASA still failed to advise her that the default judgment was already granted in favor of the plaintiff and that she ought to proceed with an application for the variation of the order. Instead, LASA continued to ask her if she intended to proceed with the matter. So in the circumstances, we are persuaded to find that such procedural irregularities by LASA, as highlighted above, singularly or accumulatively, constitute improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. So this conduct also prejudiced Mrs. Netty in that she did not have an opportunity to defend the matter and claim the pension benefits she would have been entitled to by virtue of her marriage regime. To remedy this improper conduct and maladministration, the CEO of LASA must, within 30 working days from date of this report, present a copy of the Legal Aid Board as the accounting authority of LASA for it to take cognizance of the findings made therein, and the board must discuss and pass a resolution on the report in line with its legislative powers as contemplated in Section 4, subsection 1 of the Legal Aid Act 39 of 2014, with a view to taking steps and measures in order to address the shortcomings or maladministration highlighted in this report. Such measures shall include, among other things, the LASA developing a standard operating procedure within 60 working days from date of this report, which requires that the walk-in client or complainant should sign their instructions during consultations as a confirmation of its correctness. The LASA must conduct a refresher course within 90 working days from date of this report and train the legal practitioners on salient legal prescripts relating to their day-to-day duties in order to ensure maximum effectiveness and to prevent recurrence of administrative lapses highlighted in this report. The CEO of the Legal Practice Council must also, within 30 working days from date of this report, ensure that the Council initiates an investigation and the disciplinary process contemplated in Section 37, subsection 1 of the Legal Practice Act, right, with the Legal Practice Council rules made under authority of Section 95.1, Section 95.3, and Section 109.2 of the Legal Practice Act against the licensed legal practitioners implicated in maladministration and improper conduct highlighted in this report. The second report is NISI versus GEP, the Government Pension Administration Agency, I will call them GPA. We investigated allegations of an undue delay and maladministration by GPA to submit the correct tax directive information to SARS in respect of Mr. Caspar Mnisi. This followed a complaint that Mr. Mnisi lodged in February 2021. Mr. Mnisi alleged that he retired from the Department of Education in Limpopo Province in July 2019 and was accordingly paid both his lump sum and monthly pension afterwards. In the 2019-2020 financial year, he was entitled to a salary increase which was implemented after he left the department. As a result, the portion of the increment was not included in his pension benefit. He received payment of money that was in arrears from the department through the BUS system, and that an instruction was sent to GPA to effect the increment on his monthly pension income. The GPA issued a request to SARS to indicate how much tax should be deducted from such benefits. Upon further inquiry, discovered from SARS that the money he was supposed to receive could not be released because GPA issued incorrect tax information, resulting in Mr. Mnisi incurring arrears in respect of his tax returns. Furthermore, GPA also delayed in issuing the correct information. He was advised by SARS to approach GPA to rectify the problem. On inquiring with GPA local office in Nelspruit, he was advised that the matter was being handled by the National Office of GPA. He was unable to file his tax returns because of this outstanding issue, and his lump sum payment could not be processed until the matter was resolved. In essence, Mr. Mnisi argued that the conduct failure by GPA to issue the correct information to obtain a tax directive was prejudicing him, as he could not submit his annual tax returns, he could not be paid his pension arrears, and his monthly pension allowance had not been accordingly updated. Having studied and analyzed the complaint, we decided to focus the investigation on whether GPA unduly delayed to issue the correct information to SARS to obtain a tax directive in respect of Mr. Mnisi, and if yes, whether the conduct of GPA is improper and amounts to maladministration. We concluded that while GPA may have taken the necessary steps to ensure that Mr. Mnisi's tax directives inquiry was ultimately finalized and the tax certificate issued, there was, however, undue delay in advising him when he made inquiry in December 2020 that the tax directive was corrected and or reissued. The incorrect tax directive was issued in August 2019 and the correct directive in May 2020, but the GPA only informed Mr. Mnisi in April 2021, so that the tax directive had been corrected, which led to the finalization of his tax directive inquiry. Therefore, GPA failed or alternatively delayed to take the necessary steps to ensure that Mr. Mnisi was informed that his tax directive had been issued. If the correct tax directive was issued in May 2020 and in December 2020 Mr. Mnisi was still inquiring, it means GPA delayed in processing his tax directive. Had GPA exercised due diligence and a duty of care, they would have not submitted to SARS the information which contained two lump sum, leading to the issuing of two directives, tax directives, using one directive number. So GPA would have ensured that the correct tax directive was issued in the first instance when they were providing this information to SARS. So based on the evidence above, it can be concluded that although GPA complied with Mr. Mnisi's request to have the corrected tax directive issued, it did not fully cooperate with our inquiry. We recommend that the acting CEO of GPA must, within 60 working days of receipt of this report, develop adequate systemic processes and procedures to enable correct information being processed to request tax directives from SARS. And the acting CEO must put in place appropriate preventative and directive controls and systems to address the root cause and ensure that similar incidents are avoided in future. The acting CEO must also, within 60 working days of receipt of this report, provide a report to us with regard to the nature of the system and how effective it is or it will be. So the next report relates to Mpumalanga Department of Education. This report is a result of an own initiative investigation conducted following a dispute which arose between the Manalam-Gibe community and the Mpumalanga Department of Education in respect of the affairs of Mkhwebane Primary School. On the 4th of September 2020, during nationwide visits to provinces to conduct inspections at various hospitals and rural or farm schools with the view to ascertain their readiness to cope with COVID-19 pandemic, we stopped over and conducted an inspection in loco at Mkhwebane Primary School in Mpumalanga. During the inspection, we were joined by officials of the department, namely the district director, the deputy director, the second manager, and as well as the members of the media and the South African Police Service. It was established that the school structure was in a dilapidated state and not conducive for a teaching and learning environment. That is, the classrooms were dirty with books strewn on the floor. Some of the classrooms had broken window panes. The school had no flushing toilets and relied on pit latrine with broken doors. In addition, it was established that the school remained empty on the basis that the learners were relocated to the Busisiwe Secondary School by the department in June 2020 and provided with scholar transport due to the conditions of the school. We engaged the representatives from both the department and Manala community, Mkhwebane community, and the following was established because in this instance we were conducting an alternative dispute resolution. So the Mkhwebane Primary School had a registered roll of 427 learners for 2020 academic year, with less than 50 learners residing in the area. Most learners come from Siyanqoba, which is a neighboring community. Due to the fact that the premises at Mkhwebane Primary School were no longer conducive for a teaching and learning environment, the department took a decision to build a new school. The Communal Property Association provided the department with the vacant land where a new school could be built. However, the new or interim executive committee of the CPA refused to avail the vacant land initially provided to the department for the construction of a new school on the basis that the CPA were of the view that the new school should be built on the land on which the old school is situated. The department had already erected 8 mobile structures at this new land, which is plot number 91 of the farm U Port 283. The policy of the department does not allow for construction of a school that will serve less than 150 learners. That's what the department said, and in such cases, the policy dictates that the department should transfer learners to the neighboring schools. According to the community in 2013, the former Premier of Mpumalanga and now Deputy President, Mr. Mabuza, visited the area and requested that the school be closed and relocated to Siyanqoba. However, the community refused based on the fact that there were sponsors willing to build them a school, but the principal allegedly disrupted the whole arrangement. In addition, the community indicated that the former premier allegedly stated that the provincial government was closing the school in order to save costs, and yet the department is now incurring costs of transporting the learners to Busisiwe Secondary School. The community also raised socio-economic issues in that the location of the school to another area will deny the community job opportunities such as clerical work, maintenance of the facility that they might be benefiting from having the school in the area. Therefore, they want the department to build the school where Mkhwebane Primary School is currently situated, but the department was not prepared to build the school there because of the learners being around 50 or less than 50 learners. The land provided by the old committee to CPA, provided by the old committee of the CPA to the department, and on which the proposed new school was to be built belongs and falls within the communal jurisdiction of Manalam-Gibe CPA. However, the community insisted that the land, which the department was provided with by the old CPA to build the school, was no longer available. This contention is based on the refusal by the new and interim CPA committee to have the school constructed somewhere else, further arguing that it will take away their legacy. On the same day of the inspection, as the Public Protector South Africa, we appealed to the department and the community to allow us to intervene in the discussion and dispute between the parties in order to assist them to reach an amicable solution. We also implored the community to remain objective when dealing with this issue and to find a solution that will serve the best interest of the children. Pursuant to the inspection conducted and engagements with the parties, we resolved that an alternative dispute resolution meeting would be arranged in order to resolve the matter, and both the community and the department should each propose 3 options to present to the meeting on how this matter could be resolved. Say the under-mentioned stakeholders should also form part of the proposed meeting with the Office of the Premier, Department of Agriculture, Land Reform and Rural Development, and the organized labor. Having analyzed the complaint and the information as well as the documentation received during preliminary inquiries, the following 2 issues were considered and investigated. Whether the department was allocated land for the building of the new school, but unjustifiably failed to pay the 50,000 monthly rental fee requested by the community, which resulted in the reversal of the decision to avail the land, and whether the department irregularly and improperly relocated the Mkhwebane Primary School from its current location to Busisiwe Secondary School, pending the building of a new and permanent school. Before dealing with the findings, I wish to reflect on some of the observations we made during the investigation. On the construction of temporary and permanent school premises, the department has not been able to acquire land for the building of a new school, and as such they are still interested in plot 91 if it is given to them, although not prepared to pay for it. As far as the construction of a temporary structure for temporary relocation of Mkhwebane Primary School is concerned, there are delays occasioned by the community and local business interference in the construction project at Erfdek 1 in Pine Ridge. On scholar transport, parents raised a concern regarding the roadworthiness of the buses. This was brought to the attention of the Department of Public Works, Roads and Transport for them to check and verify the roadworthiness of the buses and impose penalties for those buses not found to be roadworthy. And the department made an undertaking that the roadworthiness of the buses would be monitored. In April 2022, our investigation team conducted an inspection in loco on the route and the roadworthiness of the bus. There was one bus transporting 34 learners to Zaidhoek, the area where the original Mkhwebane school is situated. The bus may be roadworthy, but it appeared as though it needed maintenance. For instance, some seats were torn, including the driver's padlock was affixed to the passenger door. So Department of Public Works provided the investigation team with the roadworthy certificate and operation license of the bus. And parents also requested that the school provide breakfast for the children as they leave home very early in the morning. In this regard, the department cannot provide meals, breakfast in the bus because of the budget for National School Nutrition Program does not cater for the provision of meals to learners in the morning, especially in the bus. But the parents or school are at liberty to raise funds for that. The uncertainty about the schooling arrangement also impacted on the registration of learners for that academic year. In this regard, Mkhwebane Primary School was still housed at Busisiwe Secondary School. Regarding the registration of learners or lateness thereof, the department made provision for late registration to accommodate those parents. We now tend to deal with the findings. Regarding the findings, the first issue, we found that the department is not prepared to pay a rental fee for the use of land to build a school. It is the prerogative of Manala Mkhwebane community to demand rent for the utilization of their land. It is also the prerogative of the department not to lease the land from the community. Therefore, the allegation is not substantiated. It cannot therefore be concluded that the conduct of the department was in contravention of Section 14 of the South African Schools Act or constitute improper conduct. Therefore, the conduct of the department does not constitute maladministration. On the second issue, we found that the allegation that the department irregularly relocated the Mkhwebane to Busisiwe is also unsubstantiated. The relocation was justified considering the dilapidated state of the original structure. The relocation was also necessitated by the fact that the number of learners residing in the area where the original school is situated is less than 50 learners, whereas more than 300 learners were from other areas. The department's conduct in relocating the learners from the current Mkhwebane premises to Busisiwe was necessary under the circumstances, in order to ensure that teaching and learning continue to take place in a conducive environment until a permanent school is constructed. The department has confirmed in a letter dated 14 April 2022 that in partnership with Africa Sol in Yandamine has established a skills development hub at the old premises of Mkhwebane Primary School, although the initial idea was to construct a cultural center or a monument. It therefore cannot be concluded that the conduct of the department was in contravention of Section 195. Therefore, the conduct of the department does not constitute maladministration or improper conduct. We recommend, in terms of Section 64C, the Roman figure 2 of the Protector Act, that the head of the Department of Public Works, Roads and Transport should ensure that within 30 working days of receipt of this report, the scholar transport, which is currently utilized, is subjected to proper technical inspection, is properly maintained, and provide a report to us thereon. This will ensure that the safety of learners is prioritized. The head of the department must also ensure that the road from town to Zycop farm is maintained on a regular basis, and also update us on that. Then the acting HOD of the Department of Education, on the other hand, should ensure that within 30 working days of receipt of this report and after every 30 working days, provide a report to us on the benefits of taking the 34 learners who are transported to Zycop farm to a boarding school, because the department is prepared to do that. It's just that the parents are not willing to do that. The HOD should continue with the request to acquire land for the building of the new school and report to us regularly. The next report is Derks versus Majordina. We investigated allegations of misuse of public funds allocated to the ANC by Parliament as a political party allowance by the Member of Parliament, Ms. Majordina, during an award of the personal protective equipment tendered to her son's private company. The investigation followed a complaint lodged in April 2021 by Mr. Derks, an African National Congress MP. Mr. Derks alleged that the award of the PPA tender for the supply of thermometers worth 52,500 by the ANC constituency office to the company owned by Ms. Majordina's son, Mr. Tandolwetu Mkhwebane Majordina, is at face value in contravention of Section 217 of the Constitution. He also alleged that Ms. Majordina created a post of graphic design in her office and employed her son to the post without following due process, and that this deed expresses gross nepotism and disrespect of public office. In addition, Mr. Derks alleged that Ms. Majordina abused constituency funds on car rentals despite receiving monthly car allowances. Essentially, Mr. Derks argued that Ms. Majordina used public funds allocated by Parliament as political party allowances to benefit her family, and that Parliament has not put adequate control mechanisms in place to avert the misuse of public funds allocated by it as politically party allowance. Having studied and analyzed the complaint, we decided to look into the following 4 issues: whether the award of the PPE tender for the supply of thermometers worth 52,500 using public funds by the office of the ANC Parliamentary Caucus to a company owned by Ms. Majordina's son amounted to improper conduct and maladministration. B, whether Ms. Majordina created a post of a graphic design in the office of the ANC's Parliamentary Caucus using public funds and employed her son without following due process, and if yes, whether such amounted to improper conduct and maladministration. C, whether Ms. Majordina abused public funds using the office of an ANC Parliamentary Caucus on car rentals despite receiving monthly allowance, and if so, whether such amounted to improper conduct and maladministration. 4, whether the Parliament has failed or unduly delayed to put adequate control regulatory measures in place to ensure transparency, accountability, and sound management and expenditure. were used was awarded to a company owned by Ms. Majorina's son, but the allegations relating to the post of graphic designer and the car rentals were not substantiated. This, notwithstanding, our conclusion was that the affairs of the ANC do not fall within the scope of matters to be investigated by this office as contemplated under Section 182(1) of the Constitution. It follows, therefore, that we make no findings against Ms. Majorina in the three issues above. This leaves us with one issue, which is whether Parliament has failed and unduly delayed to put adequate control regulatory measures in place to ensure transparency, accountability, and sound management and expenditure of its finances. We found this allegation to be substantiated. The Speaker of the National Assembly considered that during the course of the investigation that the Executive Authority of Parliament has not yet issued regulations contemplated in Section 34 of the Financial Management of Parliament and Provincial Legislatures Act. The Speaker submitted that Parliament is still in the process of adopting the draft regulations, which are yet to be presented to the Joint Standing Committee on the Financial Management of Parliament. The Act is a national legislation which came into force in 2009. It is now 13 years later and Parliament has not yet passed the regulations as contemplated by this legislation, the FM PPLA, which is Financial Management of Parliament and Provincial Legislatures Act. As a result of the absence of regulations required of Parliament in terms of Section 34 of the FMPPLA, we find that Parliament has failed or unduly delayed to comply with the dictates of its own legislation, namely the FMPPLA. We further find that policy on political party allowances presented by Parliament was approved by the presiding officer in 2005. We were not finished with the evidence and or proof that the same policy was made in terms of the FMPPLA published for public comment and evidence or proof of periodical review as envisaged in Section 65(3) of the FMPPLA. Our conclusion is that the conduct of the Executive Authority of Parliament accordingly constituting proper conduct as envisaged in the Constitution and maladministration in terms of the Protector Adv. To remedy the improper conduct and maladministration, the Speaker of the National Assembly, acting jointly with the Chairperson of the National Council of Provinces, as contemplated in Section 5, Subsection 1 and Subsection 2 of the FMPPLA, must take appropriate steps to make the regulations concerning the allocation and use of any funds provided by Parliament to political parties or to MPs as envisaged in Section 34 of the FMPPLA. This must take place within 190 days, working days from date of this report. The Secretary of Parliament, as the accounting officer, must periodically ensure that the review of the regulations as contemplated in Section 65, Subsection 3B of FMPPLA. The next matter is a closing report. We issue such reports in cases where allegations or suspicions that gave rise to an investigation are either unsubstantiated or if office is not empowered by law to deal with such a case. The office conducted a preliminary investigation into the suspicions of maladministration or improper conduct by one or more unidentified employees of the Constitutional Court for unlawfully communicating and or leaking information concerning pending judicial proceedings, thereby bringing the administration of justice by the courts into disrepute and maladministration. This was an own initiative investigation. In terms of Section 7(1)(a) of the Protector Act, the Protector has the power to conduct a preliminary investigation for the purpose of determining the merits of the complaint, allegation or information and the manner in which the matter should be dealt with. On Sunday, 24 April 2022, the lead senior counsel for the Speaker of the National Assembly, Advocate Andrew Breitenbach SC, received a short message SMS from a cell phone number known to him as belonging to Mr. Ishmael Abraham J. of Pretoria. The SMS read as follows: Hello, Advocate Breitenbach. Read the Protector case. Tomorrow I have it on good authority that the Concord has declined to hear the Protector's rescission application. The decision will be made known sometime this coming week but not later than Friday. I thought I'd just share this with you on a strictly confidential basis. Thanks. It was suspected that by specifically sending the information to Advocate Breitenbach, Mr. Abraham J. intended to assist and favor a particular side to the litigation and to hurt or prejudice the opposing side, namely the Public Protector. Furthermore, we have already reported this matter to the South African Police Service as per Brooklyn Case 9405-2022 with a view to conduct criminal investigations against Mr. Abraham J. and or his accomplices. The SMS was in relation to separate but related civil proceedings before the Western Cape High Court under case number 8500 of 2022, in which the Public Protector was the applicant. The relief the Public Protector sought in the Western Cape High Court depended on the outcome of the Constitutional Court case that Mr. Abraham J. referred to in his SMS to Advocate Abraham J. SC. As part of the preliminary investigation, the office considered information in the Pretoria Record newspaper of 29 March 2022. The newspaper carried a story about a function held in honor of the Constitutional Court Justice Jody Golapen following his appointment to the Apex Court. The function was reportedly hosted by the Pretoria Legacy Foundation in Lodia, west of Pretoria. The newspaper referred to Justice Golapen as the chairperson of the foundation and Mr. Abraham J. as his spokesperson. The article quoted Mr. Abraham J. saying the event was even more significant that both Judge President Mlambo and Deputy Judge President Lidwaba of the Gauteng High Court were in attendance. From the above articles, a reasonable inference may be drawn that Mr. Abraham J. was personally know or may have contact or communication with certain persons based at the Constitutional Court from whom he may have possibly received information concerning pending judicial proceedings regarding the case involving the Public Protector. It was against this background information which is available in the public domain that Mr. Abraham J. was reasonably suspected to have received information concerning pending judicial proceedings before being made official from certain persons based at the Constitutional Court. Also, as part of the preliminary investigation, the office issued subpoenas to several persons in terms of Section 7(4)(a) of the Public Protector Act for the purposes of conducting an investigation. The Public Protector may direct any person to submit an affidavit or affirm declaration or to appear before him or to give evidence or to provide any document in his or her possession or under his or her control which has a bearing on a matter being investigated and may examine such person. Subpoenas were issued to cell phone networks, the Registrar of the Constitutional Court, the Secretary General in the Office of the Chief Justice, Justice Golapen, Justice Mlambo, Advocate Breitenbach SC, and Mr. Abraham J. because they access any person who would assist the Public Protector. Responses to the subpoenas were received from the cell phone networks, Registrar of the Constitutional Court, the Secretary General in the Office of the Chief Justice, Advocate Breitenbach SC, Rambeva Mkhwebane, attorneys on behalf of the Justices Golapen and Mlambo, ENS Africa, attorneys on behalf of Justices Golapen and Mlambo, as instructed by the General Council of the Bar of South Africa, and Berger Heiser, attorneys on behalf of Mr. Abraham J. All these responses were considered. While stating that this office is not empowered to investigate this matter, the Registrar of the Constitutional Court and the Secretary General in the Office of the Chief Justice indicated in their respective affidavits that there does not appear to be or to have been any contact or communication between the Constitutional Court's administrative staff and Mr. Abraham J., and that the Office of the Chief Justice, as the government department established in terms of the Public Service Act, does not have policies, regulations, or such other similar regulatory measures that govern communication, publication, safekeeping, management, and administration of the Constitutional Court's information concerning pending judicial matters. The above submissions by the Registrar of the Constitutional Court and Secretary General in the Office of the Chief Justice stand to be rebutted. As already argued, the source of Mr. Abraham J. may well be member of the administrative staff or the judiciary in the Constitutional Court, as circumstantial evidence suggests. The focus of the preliminary does not relate to judicial proceedings or court decisions per se, but to criminal and to improper act of leaking information. Such corrupt and or otherwise improper conduct falls directly in the heartland of the Public Protector's mandate, as set out in Section 6 of the Public Protector Act. The judiciary forms part of the state, and the Public Protector has jurisdiction to investigate improper conduct in state affairs. What is expressly precluded by Section 182(3) of the Constitution is court decisions. This is not about the court decision or a judicial function. Except for Advocate Breitenbach and the network providers, all the other respondents advance that view that this office is not empowered to investigate this matter and did not supply information that was required. And this was an opportunity for us to give them that OD Baldaram, the principles, well, to comply with the principles of natural justice and hear their side. Be that as it may, the weight of available circumstantial evidence established in this preliminary investigation appears to tilt the scales towards the conclusion that the sources of Abraham J may well be members of the administrative staff or judicial officials based at the Constitutional Court. The weight leans more towards members of the judiciary. An analysis of the cell phone data received from network providers shows that 18 telephone calls were exchanged between the number from which the controversial SMS to Advocate Breitenbach was made and the one registered under the name of Narendran Kolapen. These calls were exchanged between 4 January 2022 and 22 April 2022, 2 days before Advocate Breitenbach SC received the controversial SMS. The shortest call lasted for 3 seconds, while the longest took 436 seconds, or just over 7 minutes. There was just one cell phone call on the 4th of March 2022 between the number from which the controversial SMS to Advocate Breitenbach was made and the number registered under the Department of Justice and Constitutional Development, the number reasonably suspected to be issued to or used by Justice Mlam. Evidence also showed that the controversial SMS was not the first time Mr. Abraham J sent text messages to Advocate Breitenbach SC. There were 2 other text messages before, including one sent on 22 August 2021 at 21:48, in which Mr. Abraham J wrote, "Hello, Advocate Breitenbach. My name is Ishmael Abraham J from Pretoria. Parliament appeal on PP rules. I was speaking to a judge colleague about your matter pending appeal, and the following discussion ensued. I'm not certain if you are aware of the Act. The Law Reform Commission Act requires that the chairperson of the commission be a High Court judge. However, when the judge sits and chairs the commission's meeting, it does not do so as a judge, but merely as a chairperson of the commission. I thought that this snippet of information may just assist you in your case against the Public Protector. In the light of this particular SMS, it becomes relevant to indicate that the South African Law Reform Commission is an independent advisory statutory body established in terms of the South African Law Reform Commission Act of 1973. It investigates the state of South African law and makes reform proposals to the national and provincial legislature. Judge Kolapen is the chairperson of the South African Law Reform Commission. The cumulative weight of this evidence, as highlighted in the SMS, is sent to Advocate Breitenbach by Mr. Abraham J. The frequency of telecommunication or close association between Mr. Abraham J and the judicial officers are all sufficient to lay a foundation of a belief upon which to invoke Section 14(1) of the Judicial Service Commission Act. Equally, the motive behind the unsolicited SMSs sent by Mr. Abraham J to Advocate Breitenbach is emblematic of a nefarious intention and effort to commit a criminal conduct in terms of the Prevention and Combating of Corrupt Activities Act, in terms of or in terms of other statutory or common law crime offences. Accordingly, this aspect triggers a referral of this matter to DPCI for criminal investigation against Mr. Abraham J and his accomplices. The preliminary investigation further proved that the nature of this complaint invariably stretches to the judicial arena. Further, the complaint carries all the hallmarks of criminality and nefarious motives by Mr. Abramje and his accomplice. Consequently, the complaint may not be executed fully within the mandate of the Public Protector without bringing it to the attention or notice of the Judicial Service Commission and the South African Police Service and the DPCI. In line with the provisions of Section 6, subsection 4C, Roman figure 2 of the Public Protector Act, this matter is accordingly referred to the Judicial Service Commission as envisaged in Section 14.1 of the Judicial Service Commission Act. Similarly, in line with Section 6.4C, Roman figure 1 of the Public Protector Act, this matter is referred to the DPCI for further investigation of possible violations of PRECA and or crimes which may have been committed in connection with the unsolicited SMS sent to Advocate Breitenbach by Mr. Abramje and his accomplice to unlawfully influence the outcome of a judicial process in pursuit of manifestly nefarious motive. The matter is therefore closed. We trust that in the matters which we made adverse findings and took appropriate remedial action, those on which we made advisory recommendations, the respondent will implement and consider our recommendations. In those cases, we made referrals to other forums. We trust that the forums in question will give these matters a due consideration within their own independent discretions. As we conclude, we would like to take this moment to pay tribute to our Executive Manager, Advocate Stoffel Fourie, and the Senior Investigator, Marina Fourie. Today is their last day of service at the Public Protector South Africa as employees. They are retiring after 27 years and 22 years of their lives, respectively, to serve the people of this country with distinction as staff members of PPSA. A veteran investigator, Advocate Fourie is an original member of the PPSA staff, having been there right at the beginning when this office first opened its doors for service in October 1995, while Ms. Fourie, a stalwart in her own right, swelled the ranks of this institution as far back as 2000. This has been an emotional week for them and for us, but they are not the only ones leaving. Our Chief Financial Officer, Ms. Busisiwe, who joined the PPSA in 2017-18, and the Executive Manager, Complaints and Stakeholder Management, Ms. Mutsitsi, who joined the office in 1999 and left in 2006 and came back in 2017, are also leaving at the end of June 2022. While Ms. Busisiwe is pursuing other interests, Ms. Mutsitsi also is going on retirement. Under Ms. Busisiwe's stewardship, the office managed to make history. She marshaled the finance and supply chain management teams to 2 conservative clean audits, a feat that was until now unheard of in our corridors. Ms. Mutsitsi, on the other hand, has been in charge of complaints and stakeholder management, a branch which can be best described as the engine of the institution. All complaints that are sent to head office pass through her hands, irrespective of whether they come through the call center, email, post office, or walk-ins, as it is at a CSM where complaints are registered, complaint files are then opened, and complaints are then assessed for jurisdiction. So Advocate Fourie, Ms. Mutsitsi, Ms. Fourie, and Ms. Busisiwe joined a few other long-serving employees who called time on their illustrious careers by way of retirement over the last several months. Among them, Advocate Sune Grisel, and we also had Advocate Gideon Landman, who was based in our George office, and also Ms. Gidiboni Silamulela, who was based at our Mifikein office. We can't say we are happy to see them go, but such is life. We are grateful for their immeasurable contribution. This office was built on their backs, and they should be proud of their legacies which they leave behind. we wish them well. Thank you to everyone.
Thank you, Public Protector. Taking questions from the floor. And in doing so, we will request all those who wish to pose questions to first introduce themselves and inform us as to which media houses they represent, and then they can pose those questions to the Public Protector and the Deputy Public Protector. This invitation is also extended to those who are joining these proceedings via the WhatsApp platform or via the Microsoft Teams platform. Their questions should be channeled through the WhatsApp platform. Let's see, by way of a show of hands, if there's anyone who would like to pose questions to the panel before we release them. It doesn't look like there are questions, people, even on the WhatsApp platform. There hasn't been any indication as to whether there is a question for clarity or not. And then in those circumstances, I would propose that we adjourn the press conference. Thank you so much for having joined. I'm informed that our website has just went down now, but someone is attending to it to see to it that it's up, and then as soon as it is up, we will upload all of those reports that the PP has just released. Otherwise, we will be distributing the copies via the WhatsApp platform. Thank you.